Sorry, I should say everybody, I'm going to start recording. Now you all should get a pop-up message that says recording is about to start and consent. All right, good. Okay. Welcome everyone. Now while I'm sharing the screen, I can't see chat. So you're most welcome to post any questions in the chat screen and Caroline will keep track of those. If anything drastically goes wrong with my slides and I haven't noticed, please sing out to me. And please, as you've already done, you've muted your microphone, so that's great until you're ready to talk. So welcome everyone, and thank you, Professor Felicity Gary QC, for joining us today. Felicity will be talking to us today about modern slavery and human trafficking. This is a really interesting presentation, and I'm so pleased that many of you were able to join us. Felicity is admitted to the ICC and the Kosovo Specialist Tribunal in The Hague, and in Australia and in Victoria and the High Court. So you'll notice that I said Professor Felicity Gary QC. So Felicity is not only a professor, but also a QC for Australia and also in England and Wales. Felicity has also had ad hoc admission in the Hong Kong and Gibraltar. She specialises in leading for the defence in the most serious and complex criminal trials and appeals, often with an international element. Most recently, she appeared in 3 high-profile terrorism trials in Victoria. She is well known for her role in correcting the law on complicity in a range of cases across the globe and has a quarter-of-a-century experience in cases involving human trafficking and sexual offending. Felicity is a regular contributor to Broadsheet in Legal Press. She also has appeared on a number of award-winning television documentaries. She was Legal Personality of the Year in 2016 and has been recognised in the Legal 500 as a leading silk and as a fearless and independent-minded. And just to mention there, I believe that Felicity has also been nominated for the Lawyers Weekly Barrister of the Year award this year as well. So for our purposes, Felicity is a Professor of Legal Practice at Deakin University, where she lectures in an intensive unit on modern slavery, terrorism and climate change law. Felicity's research areas focus on the field of women in the law, technology in the law and reforming justice systems. She is a contributor to Modern Slavery and Human Trafficking Law and Practice. This is 2018 edition, and also Human Trafficking and Emergency Legal Issues. Felicity will also talk about books today as well, which is useful for us. And added to that, Felicity also gave evidence to the parliamentary inquiry, which led to the Modern Slavery Act 2018. So that's just a few of the many things that Felicity does. I don't want to take up, I'm just so pleased that you've got time to be with us today. So Felicity, I'll hand it over to you. Felicity will go through her presentation and talk to us. And then at the end, for about 10 or 15 minutes, we'll have questions and answers time. So Felicity, thank you.
Well, thank you very much. I'm exhausted to listening to all of that about myself. I suppose ask a busy woman, but I want to tell my little anecdote today that Michelle and Caroline know, which is I'm delighted to speak to the Law Librarians of Australia, because when I was at university a very, very long time ago, I got a job in the university library and I was a shelf stacker, and it has led to my lifelong pleasure of going to the law library, both online and hard copy, of course. I'm a sucker, as you can see behind me, for a real book. So talking to law librarians is very close to my heart. One of my best friends I met in that library, I worked with her, and she is still, 30 years later, one of my best friends. So thank you very much for having me. Today's talk, we've got our first slide, and I shall say next slide when we need to move on, I've titled it Modern Slavery and Human Trafficking because that's the language that tends to be used in both international and domestic law. But you'll learn that there is really an overlap in the sense of slavery being about the ownership of people and human trafficking being a wider and encompassing slavery and slavery-like practices. So what we're talking about is not just, for want of a better expression, the ownership of people, which is the traditional understanding of slavery, but modern slavery really encompasses this much wider definitions that have been developed over time that really relate to the exploitation of people in a range of circumstances. So next slide, please. Thank you. All right, so misspelt trafficking there. I'm sorry, every time you check, there's always something else. But as some of you may well know, the definitions and forms of slavery have varied over centuries and have caused controversy as to, well, what is it that we want to say about exploitation that is unlawful? And of course, then what sort of unlawful? Is it where you might have a remedy in civil proceedings or commercial proceedings against a corporate, or a criminal law remedy where the state can prosecute? So for those of you who are also law historians, there are centuries of slavery treaties, certainly since 1815. And as you can understand, with the abolition of the transatlantic slave trade, the discussion has really been about not focusing any longer on the ownership of people as chattels and human bondage, but these wider definitions that now existed, particularly in international treaties, that focus on wider forms of exploitation, control, compulsion. So they include slavery, servitude, forced and compulsory labour, forced marriage, and of course sexual exploitation. It's often widely misunderstood that modern slavery and human trafficking are two separate things. There is this enormous overlap. And we can think about examples that can arise in our daily lives or our daily understanding. So I've just given you some that have arisen in the context of my practice here. So I'm currently involved in a logging case in Papua New Guinea, looking at what's known as illegal logging, but what do we actually mean by illegal? What's going on? Is the law, it's got a very aspirational constitution, is the law good enough? And if it is, are the circumstances in PNG really as a result of the operation of events on the ground? But we can very quickly see the intersection between the devastation to biodiversity and the taking of timber from PNG also having an overlap with the enslavement and exploitation of the people of PNG. So one of the, I suppose it's an up or a downside, whichever way you look at it, is getting involved in an understanding of human trafficking and modern slavery makes you realise that you need to know whole gamuts of law, constitutional law, corporate law, criminal law. It can apply across the spectrum. And often I feel I'm stretching the boundaries of what I know as a lawyer. And one of the wonderful things that's happening at the moment is I have some student interns via the Deakin Law Clinic who are sort of helping to look up some areas of law. So even undergraduates can get into this stuff. Diamonds. We've all heard of conflict diamonds. We may or may not have watched the movie with Leonardo DiCaprio, but really being careful about where we might source our next jewellery. I wear my grandmother's ring that was a pendant, and I often think, oh, I'm not entirely sure where that may have come from, but to me it was third hand. But it does make you start to think about things. And if ever you have the chance to go on Google Maps and look at the Kimberley mine in South Africa, it is just enormous, and thousands of people died digging up the diamonds on the De Beers farm for Cecil Rhodes. So there's huge amounts of history in here. The De Beers, of course, sold their farm not knowing what they'd got underground, and now the mine is full of water. So it's a pretty shocking thing just to see on Google Maps. Clothes. One of the hardest lectures I gave on this topic was in the Philippines when I was a guest lecturer at De La Salle University, trying to talk to the students about not buying counterfeit goods, counterfeit handbags, because of the exploitation in those circumstances. And then, of course, I regularly talk about exploitation in drug trafficking. And it's worth remembering that the international law on human trafficking was developed as part of the Convention Against Organised Crime. So it's always been recognised that there is exploitation of people in organised crime, and now we've recognised the exploitation of people in the corporate environment. So Slavery was not abolished when they abolished the transatlantic slave trade. What happened was it was no longer made lawful to own people, but the existence of slavery obviously still occurs. So next slide, please. I've only given you one definition here. This is the protocol to prevent, suppress and punish trafficking in persons, especially women and children. It's known as the UN Trafficking Protocol, or sometimes you hear the Palermo Protocol, and it is a protocol to the Convention Against Organised Crime. I've shortened that, but it gives you the definition here, which really falls into three parts: the act, the means and the purpose. So the act is recruitment, transportation, transfer, harbouring or receipt of persons. So it doesn't cover every situation. And this is the definition of human trafficking. The means is by threat or use of force or other forms of coercion, abduction, fraud, deception, abuse of power or abuse of vulnerability, or giving or receiving of payments or benefits to achieve consent of a person having control over another person. And just pausing there to think about that, I like to pause on a position of vulnerability. You can see here that the definition is so wide that it considers the position of vulnerability. And there's a tension always around, well, can anyone who is particularly vulnerable actually meaningfully consent? Consent's not an issue in relation to children, but we can start to see here how there's been a real effort to widen the scope of what is contrary to international law. And then we can go on in a moment to think about domestic responses. So the third part of the definition of human trafficking is it's for the purpose of exploitation. And exploitation includes, shall include, at a minimum, the exploitation of, prostitution of, other forms of sexual exploitation, forced labour, services, slavery or practices similar to slavery, servitude or the removal of organs. Now different instruments have slight variations on that, but broadly speaking that's what everybody who's signed up to the UN protocol has agreed. So you can see how slavery, servitude and slavery-like practices are all included in that international definition of human trafficking. So we're really thinking about something much wider than ownership of people. Next slide, please. So the context from a practical perspective is twofold. We've got this global situation, we have global corporates, we have global supply chains that are ostensibly lawful corporates, and ostensibly unlawful organised crime, transnational organised crime, international crime. But you can start to see an overlap. If it involves the exploitation of people, where does a legitimate corporate begin and an organised criminal network end? So it's quite interesting as originally a criminal practitioner to see how much of what I did when I was solely a criminal practitioner had that overlap into corporate responsibility. And for those of you interested in the development of law on corporate responsibility, President Obama, as he then was, asked Professor Ruggie to come up with some principles. So we now have these guiding principles and a framework on business and human rights, which I've given you some of the instruments there, the ILO Convention on Child Labour, but particularly focused perhaps on the protect, respect, remedy in the guidance and framework. And then we can think about how domestically there's been some response to that framework that was agreed at international level. So we're really thinking about corporate responsibility for slavery and supply chains, organised crime, including transnational organised crime, and state responses to those issues. I've given you some legal instruments there, but I think the words in bold are probably the most useful in the sense that we're thinking about wide circumstances for exploitation and slavery, not abolished with the transatlantic slave trade. Thank you. Next slide. So the general themes that come out of all these laws that I haven't troubled with you with too many are, in criminal law, the mantra is prevent, protect and prosecute, which makes perfect sense, doesn't it? I mean, labels are always useful for us to get our heads around what we're supposed to be doing. The exploitation of people is, our perception is that that's something that the state ought to be involved with. It has that criminal feel to it. Therefore, if we can prevent it happen, we prevent the exploitation of people. We should protect those people who are exploited. So if, for example, that it is discovered that there is slavery within a factory producing garments, for example, the answer isn't necessarily just to close the factory down, because you can start to see how those persons who were exploited within that factory would suffer even more greatly. So the concept of protection is about ensuring that those people who are exploited are not left to be exploited again or re-trafficked again. That's quite a hard concept to think about in any area of law, that there become positive obligations to do more for victims. And then obviously prosecution of perpetrators. And I'll come to domestic law a little bit later on. But the mantra, prevention, protection, prosecution. In corporate law, the mantra from the guiding principles is protect, respect and remedy. So we can see that theme of protection that comes through the two. Respecting human rights, for example, and then providing a remedy. And when I gave evidence to the parliamentary inquiry in relation to the creation of the Modern Slavery Act in Australia, one of the real concerns was how much is it going to cost to provide a remedy to all these people all over the world in supply chains. Part of you wants to say, well, I don't care. We really ought to be providing remedies for people who are exploited. But of course, economically, that becomes the primary focus. So you can start to see how difficult it is to get the wheels moving on these areas of law. For those of you really interested in looking the law up, if you like, or getting the right books into the library, I've given you an example of the international law. It's worth noting that the development of this law is much further ahead in the EU. There's a convention on human trafficking. There's a directive that has direct application in all of the EU member states, 28 as were, 27 now. And of course, ASEAN, the ASEAN Convention contains these same themes and these same requirements. So they're all ahead of Australia. Australia's quite a long way behind. Next slide, please. Some reading material here. I decided not to go into it in too much legal detail, but what's quite interesting in the concept of abuse of vulnerability is, what do we mean by vulnerability? How wide is it? And you'll start to see the issue papers here. I've given you one link on what does abuse of vulnerability really mean. You'll start to understand that when I come to some case examples a little bit later on. And then part of the protection element, this idea of protection is not to punish, and it's moved on to not to prosecute those people who are exploited. So what we tend to end up with is, particularly where abused people commit crime, drug trafficking is our best example, exploited people committing crime, particularly children who are used by as drug couriers, for example. The principles for protection here are about non-prosecution, non-punishment. So you no longer have swathes of vulnerable people coming through the criminal justice system, and you aim for the people at the top, which is a very sensible concept, much harder to get people to buy. Not prosecuting people is not the current message that we hear politically. Next slide, please. Well, as I say, that last slide was really for those of you who want to take it further, have a look at those two links. But there's some data here. If you're interested in data, have a look at the Anti-Slavery Australia website. They give you these shocking figures. 40.3 million people living in modern slavery, that wide definition that I've given you. 15.4 million in forced marriage. Some of this sounds so historical and yet still happening. Forced labour, you can see numbers. 24.9 million, 4.8 million people in forced sexual exploitation. You know, I haven't read them all out, but you can start to see some pretty shocking figures there in relation to the exploitation of people. Next slide, please. So I thought it might be useful to tell you a few stories. Barristers always like to tell stories and professors always like to tell stories, so that's what I'm going to give you. I'll canter through these because I'm rubbish at keeping an eye on the time, and I can talk for England on this topic. So Michelle will have to frantically wave at me if I'm running out of time. But I first became interested in all of this when I represented a young woman not long after the criminal laws had come into force that you could prosecute people for being human traffickers. She was charged with being a human trafficker. And the prosecution case, it was quite old-fashioned language, was that she was the madam, which is not a language that you use when you're dealing with sex worker cases now, but that was the language that was used back then, and it's not so long ago. For an Albanian gang, and the story was that they'd imported very vulnerable young women from Lithuania. They'd been raped and forced into sex work, and they'd escaped, and the gang members were on trial, and my client was on trial alongside them. Now, only last year in 2019 was some very useful research published about the victim offender paradigm, and particularly what I said in 2006, which is that in order to survive, women tend to climb the ladder if they can. And I was convinced that all she'd done was, she'd been trafficked herself, she was from overseas, and all she'd done was try and survive. And it didn't seem right to me that she was on trial at all. For basically, the main evidence against her was some text messages that appeared supportive of what the men were doing. Without a real understanding of that victim offender paradigm. Anyway, she was convicted and went to prison for 7 years. We tried to appeal. We were unsuccessful. I thought she was marvellous. She was a survivor. And as far as I know, she went on to work on cruise ships. So I hope she's okay in the current environment. But I was very fond of her in the end. And I just felt that it was an injustice, or at least a lack of understanding of the issues. In 2008, I defended a man who was accused of being part of a conspiracy to import illegal immigrants from India via South Africa into Britain. And it was plainly a case of indentured servitude. It was charged as a conspiracy. Nobody had really taken any notice of the indentured servitude issue because it was all about whether it's a conspiracy. And for my client, the issue was, well, was he a conspirator, or was he someone who was being moved from India via South Africa when there was a time when it was easier to get into Britain from South Africa at the breakdown of apartheid? And you can think of that politically, you know, why did they make it easier for people to leave? And I understand the situation was the same in Australia, which accounts for large numbers of South Africans in Perth. But aside from the politics, our case was, well, no, he was one of the people being moved from India into the rag trade in that town in Britain. So he was being exploited, and he wasn't a conspirator. And he was the only one out of 26 defendants to be found not guilty. I thought quite properly so. But then off he went. No question of protecting him. He no doubt went back into a situation of being trafficked. So the protection didn't work there. When I came to Australia, before I was admitted as a barrister, I got myself a job at a university living in Darwin. And as you know, universities like you to do research. And I thought, well, I'll research this issue because this has really troubled me in these cases that nobody seems to understand modern slavery and human trafficking. But I'm not just going to compare Australia and English law. I'll have a look at what's going on around me. So I looked up the law in Indonesia and the Philippines, and I got an email that said, sign this petition, save Mary Jane Veloso. And it turned out she'd trafficked drugs from the Philippines into Indonesia. She'd been convicted of drug trafficking, and she was on the same death row as Australians Chan and Sukumaran. And she had been trafficked to carry those drugs and deceived. You'll remember deception in the definition I gave you earlier on. So her case was, I was deceived. I didn't know the drugs were in the suitcase. Now, it doesn't matter whether you believe her or not. That was the issue in the trial. And therefore, in the trial, there should have been an understanding of the human trafficking issues as on that issue of deception, and also whether she should be punished at all, whether she should be prosecuted at all. Philippines have signed up to this a long time before England and Wales, a long time before what we're doing now in Australia. There's all sorts of protection in the Philippines and in Indonesia. So instead of signing the petition, I got hold of the lawyers in the Philippines. I won't tell you what exactly the conversation, because that's subject to legal professional privilege. They used the human trafficking referral mechanism. She was The recruiters were identified. They've since been convicted of trafficking other people. The important part was she was not executed. She was given a reprieve 30 minutes before she was due to be shot. She'd gone to the island, said goodbye to her mum and her children, and 30 minutes before she was due to be shot, she was reprieved. She's still on that reprieve. There's still some law to do. But it just shows you how this can be relevant both nationally and transnationally. And there's a link there to the Foreign Correspondent Programme. So I was lucky enough to then talk about the corporate issues at conferences on the G20 gender equality targets, so looking at issues for women in corporates and in organised crime. I'm trying to do my PhD by publication on all the stuff that I've published on this, including game theory and human trafficking, so matching Aristotle's idea that the mean between two extremes of unfairness is the same as Nash's understanding of an equilibrium in strategic games, that you can always reach an equilibrium, which fits with the prisoner's dilemma, for those of you who know it. And if you don't, you'll remember Russell Crowe played John Nash in A Beautiful Mind. So it's all about choosing the brunettes instead of the blonde. And there's a paper out there, should you wish to put it in your library. All right, so I'm very happy to be teaching these topics in Deakin in my unit, Contemporary International Legal Challenges. Next slide, please. Likelihoods of these things happening in Australia, very high, but numbers are poor. The Hidden in Plain Sight report is about 300 pages long. So if you really want to know the likelihood, get somebody to read that document for you. There's fantastic evidence in it. The fundamental problem is in determining prevalence really is we have underreporting and underdetection because people can't put their hands up to say I'm exploited, or actually don't understand that they're being exploited, depending on the extreme nature of what's happening. But we can assume that modern slavery is more prevalent in Australia than the statistics suggest. Next slide, please. You can start to think of areas: fruit picking, domestic servitude. You can go on the Australian Federal Police website. They say, look, we're dealing with human trafficking. We've had a few hundred. So they're trying. There is a mechanism in which you can put people with the AFP, and I've certainly got one case going through in that way. It's quite interesting. If you have a client in Victoria that's being investigated by the police, for example, you could put that through the AFP mechanism, and you sort of set two police forces off against each other so they learn to be protective, which I think is very important. Protect and serve, you know, as the Americans would say. So the Hidden in Plain Sight report also says that intelligence suggests there's high prevalence in certain areas, and there's an example from Victoria there. Next slide, please. So what's Australia doing? Well, there's a Modern Slavery Act that came in 2018 after the parliamentary inquiry, and is solely relates to corporate law. So they only did a little bit. The Modern Slavery Act in England and Wales came in 2015. So a lot of the inquiry focused on, should we be doing the same as the UK? The answer was, well, yeah, but we're not going to yet. So they only dealt with it. It's a tiny piece of legislation. It's about 3 or 4 pages long. They said, what we're going to do is require corporates to report on slavery and supply chains. England and Wales does the same with a 3-year review. But what Australia did, 2 things that were very smart. First of all, they had criteria. In Australia, we love a form. We love criteria. So there are criteria that you have to report against. So in England and Wales, it's give us a report, we'll have a look at it. You can even report by saying, well, we're not going to report, and that's enough, which is a bit odd. In Australia, at least, there are some mandatory criteria to report against. But it's not about, the Modern Slavery Act itself is not providing remedies. It's about encouraging corporates to examine slavery in supply chains, sort of confess and avoid. If they find it, the idea is that protect, respect and remedy. So the idea is to get the corporates involved in weeding out modern slavery. So I've given you quite a lot to read there. It's meant to be about greater understanding, greater reporting, monitoring, but there's difficulties collecting the data and no real reporting yet as to slavery being found, which I think will be quite interesting as it goes along. The second really interesting thing that Australia did, somebody in government was very smart and knew what they were doing, because I'm not entirely sure the politicians realised, but somebody decided to include government. And that is fantastic. Government over the threshold for reporting or under the threshold for reporting, don't worry about it. The corporates, only massive corporates with a threshold of over $100 million have to report. But including government means that every tender, much smaller organisations now have to, in order to tender for work with government, have to demonstrate that they have looked at slavery in supply chains. So the knock-on effect of government involvement and government requirements, really good one in my opinion. All right, so there is a Modern Slavery Act there. I've also put at the top of this slide in the list the Criminal Code Act 1995, because that was updated and amended. Two sections, 270 and 271, makes it a crime to commit modern slavery, which includes that definition that I gave you earlier on from the UN Trafficking Protocol. So all of those behaviours are criminal. So there are two pieces of legislation now. One is about prosecuting traffickers. The other is about requiring corporate reporting on slavery and supply chains. So you can start to see those two themes we looked at earlier on emerging. Neither piece of legislation contains a defence for human trafficking victims who commit crime, which is the area that I'm particularly interested in. Just going back to our logging example, out of interest, there is legislation in Australia that makes it a crime not to use due diligence in the importation of timber. It's recognised that illegal logging is a huge problem. Australia's got this great law that says you've got to use due diligence in the importation of timber. Bunnings is caught by the Modern Slavery Act and does quite a good modern slavery report, but there are no sanctions. So it's not a crime not to report slavery in supply chains, but it is a crime not to use due diligence in logging. And I think there's some joined up thinking to be done there. Do we put modern slavery into the logging legislation, or in order to create that due diligence includes modern slavery in the context of logging? So we can start to see, although Australia didn't do very much to start with, there's real scope for expanding the responses to modern slavery and human trafficking. So the Hidden in Plain Sight report said, yeah, we can do what the UK has done and we can do better than what the UK has done. So I'm confident that in the reviews of the modern slavery legislation, these types of issues, so protection for human trafficking victims exploited in organised crime, or greater reporting requirements in certain specified corporate situations, logging, work health and safety, for example, will be the sort of areas that Parliament will start to look at. And what's important about the Australian approach is there's sort of bipartisan agreement. So politically, everybody agrees we should do something about modern slavery. We just want to understand what to do next. There's always a bunch of blokes that think it's always about sex. You have to sort of teach people that that's not what it's about. It's much bigger. It's about labour exploitation as well, particular problem for women and girls. So there's a lot of learning to be done within Parliament, but in principle bipartisan agreement. So there's a lot to do on data collection, issue identification and progression. Next slide, please. We can see some issues here. I've probably mentioned most of them already, but the Modern Slavery Act in many ways creates broad responsibility for the whole of the Australian population and looking externally. Criminal Code has recognised that this is a crime. So we've moved from it was lawful to own people to it is now a crime to own people. And that, I think, really encompasses what we've done. It's taken 200 or 300 years but we've moved from it being lawful to own people to it being a crime to own people, and we've widened it to exploitation. Sadly, though, in Australia, very few prosecutions, so a lot to be done in that area. We can see some of the issues. Which corporate entities and government departments have to report? What are the levels of compliance? Lots of research potential there. What evidence is there of human trafficking and modern slavery and supply chains of businesses below the threshold? Should this be something that is raised more than a Fair Work Act claim, but as an issue of work health and safety, particularly for women? What are we doing about transnational investigations? How do we investigate what's going on if the supply chain is overseas? We can't just turn up and investigate. There's all sorts of international cooperation. What does remediation mean? Protect, respect, remedy. The language of remediation in the corporate context, I'm often asked, you know, what do we do if we find slavery in our supply chains? And broadly speaking, the advice is likely to be, I'm not saying this is advice that I've ever given, but I may or may not have done, I'm not telling you, but if there is another supplier that can supply that item, it's much more likely that the corporate is going to move supplier, change the supply chain. Now, that doesn't protect or respect the rights of those people who are being exploited. Again, it removes their access to employment, health and well-being, whatever is the issue. The conventional thinking is that there should be work done to take slavery out of that supply chain, to work with the supplier to improve the situation. But you can start to see how corporates would be much happier just moving supplier, where they can be more confident in the supply chain. So I think that's a real problem, how to encourage corporates to continue to work with suppliers where slavery has been found. And there's a real worry in the corporate sphere that this would be that expensive cost that was identified when we gave evidence at the parliamentary inquiry. So I think what remediation actually means is a really interesting area for research and understanding. When and how are referrals and decisions made not to prosecute people for human trafficking and modern slavery? Clearly it's being done. The AFP are saying they're doing it. But, you know, if people have to confess to a crime in order for the AFP to examine whether or not they're trafficked, and that confession has no protection, it could be used against them in criminal proceedings, are they really going to cooperate with the federal police? I suspect not. When can we use defences that already exist in law, like duress or necessity? Should there be more defences like coercion? In England and Wales, there is a human trafficking defence. So if you've committed a crime and you committed that crime as a result because you were compelled as a victim of human trafficking, there's a complete defence for some offences. So drug trafficking is a good example. And English investigations have moved on now so that the police might attend in relation to a drug operation with social workers, safeguarding. And there are some really good numbers coming out of what's known as the county lines investigations from the National Crime Agency, that you might arrest 300 people in a drugs operation, 150 of whom are exploited children, so don't prosecute them, put them in protection in some way, see what protection they need. And I think the numbers are, in one of the operations, about 55 that go through the human trafficking referral mechanism. So an understanding that policing isn't just about picking people up and shoving them in prison, that there are better ways to prevent, protect, respect and remedy. I think there's some really interesting research to be done on when these issues are raised in sentencing in Australia. While there isn't that protection of criminal law for those people who are exploited and commit crime, how often is it raised when a counsel is mitigating in defence of those individuals? Is it reducing sentencing? There was a good project in London where they interviewed 12 drug mules, female drug mules, and it led to a change in sentencing practice once the judges understood through the sentencing council how exploited women were. And that's only speaking to 12. Why that wasn't greater, I will never know, but it's something that I've pushed at for a very long time. Next slide, please. I think we're nearly there if there's any questions. I've mentioned the Modern Slavery Act UK. It's worth saying that was 2015, 3 years before Australia. Philippines legislation's been around since, I think, 2006. Indonesia, I think the original one was 2012. Might have been, the original one might have been 2007. So source countries where it was understood that slaves were drawn from to destination countries like Australia and the UK have had this legislation, protective legislation, for years. They don't use it very well, but the Commonwealth very much behind the 8 ball. The UK much further ahead than Australia. It started with that trafficking directive I told you about earlier on that had direct effect. I know we've only got 15 minutes left, so I'll canter through. The direct effect that it had immediately was that people appealed to the Court of Appeal, and the Court of Appeal said, all right, we'll quash those convictions of those people who were exploited, because had their exploitation been known at the time, they would never have been prosecuted. So how weird is that? That's the Court of Appeal applying a policy. Not duress applies or coercion applies as a matter of legal principle. Actually, we're just going to apply this policy that they would never have been prosecuted, a form of abuse of process. So a bit to be done on legal foundation, but those appeals happened. I've got one ongoing at the moment. The legislation provided this complete defence. It's not great because it excludes a load of offences, but it's a start. Guilty pleas are a problem. My game theory paper really worked out that structurally we still put pressure on people to plead guilty rather than work out what the moral culpability is. And I did say I'd talk about books, so I think we've got a picture of it, possibly on the next slide. We'll go to the next slide anyway, we'll get there. I'll come back to books. So back to stories about me. I've got 2 current appeals for victims of human trafficking who've committed crime. I give remediation advice. I've got an ongoing death penalty study in the Philippines, where people are at risk of the death penalty even though they're trafficked victims and exploited. I'm doing a report for ICJV on whether Victoria should have its own Modern Slavery Act to include criminal law, because most criminal law is for the states. Just the Commonwealth Criminal Code deals with more serious offending. I've made a submission to the consultation on the National Action Plan for 2020 to 2024 on tackling human trafficking. Submission to the UK on the improvement of the UK legislation, and taking part in this book that will probably come up on the next slide. Eventually we'll get the picture of the book. Let's go to the next slide. No. I also helped with the Law Council of Australia submission to DFAT on the International Strategy on Human Trafficking and Modern Slavery. I won't read this slide to you. It's worth reading the whole report. It's available on Google. You can just put that title in and Google it. The Law Council of Australia's submission was dated the 11th of May. My little bit in there, paragraph 73 to 75, you can read the last few words. That it's also really important in relation to the death penalty that we do something about, particularly Australians, for example, who are arrested abroad on drug trafficking that may have been trafficked, that we do more than just give them one of my clients said all that diplomatic processes do is they turn up and give you a banana in a cage. So we actually have to do a bit more than just going to visit people who are arrested abroad. Next slide, please. There's the book. All right, so with Philippa at Southwell, she co-edits this book. She's a mate of mine. She instructs me in those appeals. This is the 2018 edition. I contribute to 3 chapters and the second edition is coming soon. It's all the law, practice and procedures in England and Wales. Really useful on some of the practices and procedures for Australia, but I reckon there's scope for an Australian version if I ever have time. All right, so final slide, I think. Yeah, there's some links to me, all about me. But my unit is dealing with all of these issues, and the students start on Monday with an option to choose a research question that they'll provide a research essay, but also to make a submission to government on how the Modern Slavery Act could be improved. So the work that they do will form part of a submission to government. So it's got clinical and research aspects. So I told you I could talk a lot. I don't know if there are any questions, but if there are, I'm happy to answer them. Caroline, have we got any questions?
No, not as yet. I've got to say, Felicity, that was really fascinating. And I'm tempted to ask, how do you fit everything into your...
Yeah, well, I'll answer that question. At the moment, very recently, I was reading some, you'll think I'm very weird, but I was listening to an audiobook on the Greek myths, and I was reminded of the women who were the Furies, you know, in Greek mythology. And I'd been going around saying, I'm furious about everything. And I was interviewed yesterday about sexual harassment in the legal profession. I was furious about that. And I realised I'm like the Furies in Greek mythology. I'm just cross. And when I come to going on holiday, I'll just collapse and go to sleep. So I don't know, same as everybody, supportive family, trying to time manage. I eat too much, you know, I eat to keep going. But I think it's when you feel strongly about something, and when I think the important thing in the Mary Jane Veloso case was, from a lawyer's perspective, is I knew the answer. And all I had to do was share it. It took me 5 minutes to write an email to say, I think I can help. And I think that's the other point. You feel cross about something, but if you have that knowledge from either academic experience or as a practitioner, you should really share it. So again, it's why I'm talking to all of you today, because if you all set up a modern slavery, human trafficking section in your law libraries, for me, that's an achievement. You know, if I can persuade you all that this actually crosses over virtually every subject that's taught in every university, you can think social sciences, education, law, you know, there's an opportunity for a slavery and human trafficking section, or also having a look at where the holes are from a library perspective. What do we have on this topic? Are there any books? You know, I've got 2 of them in my unit, but where is it being written? Should they all be in one section? Is this something that we think of as history and not as modern? So look, it's sharing or oversharing, I think, about something I just feel very, very strongly about. Sometimes I can just talk about it, sometimes I can do.
No, absolutely. Does anyone else have any questions they want to ask Felicity?
While they're thinking, I get this a lot because I talk at people and it's such a lot to take in. And I think for me, that always makes me realise how little people know about human trafficking, modern slavery, and how much we are led to believe that it's all over. You know, I often think about, sometimes the way I think about it is, we all know about those terrible slave ships. You can see the pictures and the plans of the people in those little slots on the slave ships. I once went to Zanzibar and saw the cells that hundreds of people were kept in that were tiny and disgusting, with a drain in the bottom. And if you match those to the backs of lorries, people in the backs of lorries, there's been a recent story from the UK of people being found dead in the back of a lorry. Frankly, it's just the same. And, you know, one of the pieces of research I did was for the UNODC on the overlap between smuggling of migrants, human trafficking and cybercrime. And I haven't talked about the cybercrime aspects today, but you can imagine grooming and exploitation on the internet is a huge topic. And so I think that's the comparison between old and new is often quite a good idea. To think about slave ships and slave lorries now means that we haven't come very far. We're you know, some steps forward, but not as far as I'd like us to be.
Any questions?
Hello, it's Mark Norman here. Just a quick query about what's happening in Australia. Are you, from my understanding, from what I know, is obviously we've got the federal law. New South Wales has a modern slavery act already. What are the other jurisdictions doing to implement something similar?
Well, the answer to that is I don't know, but I know that the certain MPs in Victoria are interested, obviously, because I've been talking to them. I think that the other states were on hold to see whether or not there was a constitutional issue as between New South Wales and the Commonwealth, because there was a question mark over whether this related to trade and commerce, and therefore the powers under the Constitution meant it was all a federal issue. And I think that took some time to iron out, and the New South Wales legislation will now move forward. And I suspect the other states and territories hung on to see what would happen. The interesting part about the New South Wales legislation, which I haven't put in the slides, but I'm happy to talk about, is that the threshold is much lower. So commercial and corporate organisations, let's call it that neutrally for the moment, in New South Wales, the level is, I think it's 50 million rather than 100 million. So anybody with those sorts of figures, it requires more reporting. And secondly, they have a modern slavery commissioner, which I think is really, really important. I don't quite understand why there isn't one at federal level, so that these sorts of issues can be driven by someone who has knowledge and expertise and is in a position to present the matters to parliaments that are very, very busy and don't always understand the issues. So I think the answer to your question is it will very much be on the parliamentary business, both at state and federal level, to use that awful phrase, going forward. And I think probably affected somewhat by the current pandemic, but certainly the conversations I've had, including this week with parliamentarians, is there's real bipartisan interest in progressing this. So what's happening? I suppose the answer is I don't know, but I think one of the things you've got to think about is the reporting. So there'll be some monitoring of how the reporting's going. And the fact that the parliamentary inquiry said we're going to do better and this is just a start, I think means things will happen. Exactly what will happen first, I can bet money it'll be corporate rather than crime. And the idea of selling a defence to parliaments for criminal activity is a tough one that I'm prepared to take on. So I don't know, straight answer to your question, Mark, is I don't know, but the hopeful answer to your question is a little bit at a time, and I think it will progress rather more quickly once Parliament and all the parliaments understand what they're dealing with. If I've got time, I'll tell you a little anecdote from when I lived in Darwin, which was I went to a meeting of a Women Lawyers Association, and I wasn't going to be on the committee because I was too busy, but I was quite keen to take part. And I suggested we perhaps support a charity that was a particular charity going in and meeting women who were working in the sex trade, who'd come to see me because they were worried about those women being exploited. And it was a religious organisation, and the decision was that the charity, if they were going to support a charity, they wouldn't support a religious charity. And I said, but the trouble is they're the only ones getting in to see the women. And then one of the women said, oh yes, I see those women from my office. They come in for about 3 weeks, they're controlled on an iPad, and then they leave. So there was this situation of fly in, fly out sex workers in Darwin that women lawyers were seeing, but because they didn't know about the issues, didn't necessarily think about whether or not those women were being exploited. So even though they didn't support the charity in the end, that event educated all of those women lawyers, some knew, some didn't, as to what you might be looking for and what you could do, you know, to report through a referral mechanism or to the police, or to consider what's going on. So that was a learning exercise for them. And I think most of this is about education, and corporates are learning pretty quickly what they have to report on, which is very, very interesting.
Okay, so I think we might need to finish up. We're just a couple of minutes before 1:30. Felicity, I'd really like to thank you so much for giving such a fantastic talk, and there's so much, you know, involved in it. It's quite amazing, of course. So yeah, it's really great. And Michelle, thank you for doing the organising for the session as well.
Yes, thank you to Michelle from me too. I gave a student version of this, so she got me working hard to do the law librarian version. Thank you very much, and thank you all for coming and listening to me rattle on about what I think is so important. And if you can find a spot for a modern slavery and human trafficking display in your library, then I feel I've achieved something.
Fantastic.
And
we will.
Go on.
Sorry. We will, hopefully if the recordings worked, we'll add that to the ALA website as well. Sorry, Michelle.
No, that's okay. And I will have a PDF copy of Felicity's slides. If perhaps if I email them out to all participants today, will that be fine?
Yeah.
Yep. Okay.
Certainly all right by me, yes. Make sure you save it so they can click on the links, because there is a way of doing that, so that's great.
Yes, there is. Yeah. There is. Great. All right. Well, that's our time. I'll stop the recording now and